The due diligence approach to the global governance of business and human rights gained significant momentum with the adoption of the UN Guiding Principles on Business and Human Rights in June 2011. In the intervening 10 years, human rights due diligence has become the dominant paradigm and has influenced regulation at the national, regional, and international levels, including with regard to labor rights. This chapter will explore aspects of the HRDD approach as it applies to labor rights in global supply chains in greater detail, and will note both the potential and challenges of this approach. This introductory session is meant to provide a brief overview of what has happened in the last 10 years and where we might be heading. First, I want to review the key elements of due diligence. They include identifying and assessing actual or potential adverse human rights impacts that a business may cause or contribute to through its own activities, or which may be directly linked to its operations, products, or services by its business relationships. 2. Taking appropriate action on findings from impact assessments. 3. Tracking the effectiveness of measures taken to address adverse impacts. And 4. Communicating how impacts are being addressed and showing stakeholders, in particular affected stakeholders, that adequate policies and processes are in place. At the international level, the human rights due diligence approach has been incorporated in several non-binding frameworks, including the revised OECD guidelines on multinational enterprises, the revised ILO Tripartite Declaration of Principles Concerning Multinational Enterprises and Social Policy, and the sustainability framework of the IFC, the International Finance Corporation. At the national level, the human rights due diligence approach was initially applied to the issue of forced labor and human trafficking. The first of such laws, the UK Modern Slavery Act, passed in 2015. It is, however, quite limited, as it only calls upon businesses that are covered by the law to prepare an annual slavery and human trafficking statement. UK-based NGOs and unions have found, however, that many covered businesses either do not comply or do not issue meaningful statements. In 2018, Australia passed a more robust version of the Modern Slavery Act, which requires a company's anti-slavery statement to discuss the due diligence and remediation that the company undertakes. The Modern Slavery Act is still pending in the legislature of Canada. Of note, in June 2021, a bill was submitted in the House of Lords of the United Kingdom, which would amend the Modern Slavery Act and would add additional disclosure requirements and create civil and criminal offenses for issuing false statements or continuing to source from suppliers that fail to demonstrate minimum standards of transparency. Perhaps the most significant national legislation outside of the modern slavery paradigm is the French Duty of Vigilance Law. Under that law, adopted in 2017, companies must adopt a vigilance plan identifying risks to human rights, and the company may be liable if a victim shows that the company could have prevented the harm. A Swiss effort to amend the Constitution to adopt a due diligence framework narrowly failed in 2020. On June 11, 2021, the German Parliament passed the law on corporate due diligence in supply chains. The law will establish due diligence obligations for companies that extend to the entire supply chain, though with more stringent obligations with subsidiaries and direct suppliers. However, critics have noted that the bill includes no liability provisions for situations in which companies have been implicated in serious human rights abuses and failed to conduct human rights due diligence. It also does not require companies to consult with stakeholders at all stages of due diligence. The efforts by EU member states have led the EU to work towards European-wide regulation. In February 2020, the European Commission presented a study on options for regulating due diligence in global supply chains. In February 2021, the European Parliament's Legal Committee adopted a draft directive on corporate due diligence and corporate accountability, and called on the EU to legally require companies to respect human rights and the environment in their supply chains. This was adopted by a resolution of the Parliament on March 10, 2021. While the Commission has committed to tabling an EU-wide human rights due diligence law, it has not yet done so. In the following video lectures, my colleagues will discuss specific aspects of due diligence with reference to a recent ITUC publication on the elements of an effective human rights due diligence law.